IRAC, or the IRAC paradigm, is sometimes referred to in a different way, like CREAC, CRAC. They are all basically the same things. They're very much related. And what they are systems of organization for legal thought. They are a container for legal thought. So when you think about IRAC, I don't want you to think about IRAC and the IRAC paradigm as legal analysis in and of itself. Instead, I want you to think about it as a container for legal thought. So on one side of this graphic, you see coffee beans. They're just in a random pile, not necessarily particularly orderly. They look like someone just kind of dropped them there. That is just a bunch of legal thoughts that are not necessarily organized. But on the other picture, you see the coffee beans neatly contained in a container, right? You can see through it, you can see the thought, but it's contained in a way that's helpful for us. So I want you to think of IRAC as the container to organize your legal thoughts. It really is a formula that we as lawyers use to communicate information with one another. So what is IRAC? So it's rule-based reasoning, and I have a bit more on rule-based reasoning on my podcast or on my blog if you're interested in getting into depth on rule-based reasoning versus analogical reasoning. But rule-based reasoning here, we'll just deal with it very high level. It's what you're asked to do on issue spotting exams. And nearly all of your first year courses will have some form of an issue spotting exam. So what that means is that you will be presented with facts giving rise to a legal problem. And there's a reason that we do this. You know, if you hang up a sign that says, whatever your name is, Esquire, legal services, someone's going to stumble into your office and just tell you a whole bunch of facts. That person doesn't necessarily know what the legal problem is, but that is your job as the lawyer to spot the issue in the facts presented to you and be able to deal with those in a meaningful way. So how do you do that? So your job in practice and on an exam is to figure out and be able to communicate the legal issue raised by the facts, the rule that governs the legal problem, and we don't just stop there, because really anybody could memorize a set of rules or be able to look up a set of rules. But what's really key is the next step, the ability to apply the rule to the facts provided. So the application is really what lawyers get paid for. And then the conclusion reached in light of the analysis. How is this likely to come out based on that application, based on your analysis? So why do we even need a formula? Let's say you're an English major in undergrad and you feel that you're a very strong writer and you think, boy, I'm used to the way I've been writing and it has brought me success. I was a poli-sci major or maybe a sociology major. Why can't I just write the same way? And the answer really comes down to who is receiving the document. So we want to train you to write documents that generally are read by very busy people, very busy users, as I call them. So on the black and white image, you see someone just looking kind of relaxed. He's leaning back a little. He's smiling. This is not your general reader of legal documents. Instead, the person using legal documents is often the person in the colored picture who's wiping his brow, he's looking at his phone, checking something in a book, drinking a coffee, has a calculator maybe for calculating damages, looks like he's reading some legal papers. So we are not a reader in the traditional sense, in that when we get a brief or an exam that we're laying in a hammock sort of reading it for pleasure. Instead, we're very busy people. Generally, we work by the hour. We're often interrupted while we're working with complex legal documents. And by using the same container or the same formula in all of your legal writing, it helps the busy user to be able to find the information the person needs quickly. And that person also is your professor. So here we have this person staring up at these big stacks of papers, which are meant to symbolize your exams. So one of my colleagues this past semester, had 200 property exams to grade. Needless to say, he gave them all adequate time, but if he really read them very slowly and methodically, he might still be reading them maybe 4 months later. Instead, by using the IRAC paradigm, that professor is able to look to your answer and say, okay, did this person get the rule? Did this person apply the rule, right? It's an easy way to locate things. So there is some thinking behind why we do use this formula as lawyers. So IRAC in and of itself, it just stands for the first letter of all the words that make up the IRAC paradigm. So the issue, the rule, the application or analysis, some people call it, and the conclusion. So that's what IRAC is. It's new to you now. It will become second nature to you eventually. But let's talk a little bit about each of those components. So first, the issue. The issue really serves two purposes or takes on two forms. So the first is something not everybody does, but I do recommend it. It could be a heading. So let's say you have a battery question on your torts exam. You can, often on torts, for example, intentional torts, when you're being tested on that, there's numerous torts involved. So one might be battery, one might be assault, one might be false imprisonment, and things like that. And so having a heading that says battery or false imprisonment signals to the busy user, the busy reader, your professor, this is what I'm going to talk about here. So it often takes the form of a heading, but it always takes the form also of either a question or a statement that starts your writing. So in undergrad, when you went to go write an essay, you probably rehashed a lot of the facts that were given to you to sort of set the stage for what you're about to say. In law school, you don't get any points for that beautiful writing. The professor knows what the facts say, and the professor doesn't need them simply recited. Instead, in law school, we start with the issue or an issue statement. So, did Amy commit battery when she insert facts? Right? That's a question. Or a statement might be, the issue is whether Amy engaged in battery when she fill in the relevant facts. Okay, so really it's nothing more than what the judge needs to decide, what the legal issue raised in this case is. What question are we answering? Okay, so the rule is a general statement of law that's applicable to future cases. So we're not going to say Amy engaged in battery when she blah, blah, blah. That's not a rule. A rule is something that you pull from a case or series, you synthesize from a series of cases that you can apply to future cases based on similar facts. So to use an example here, and this is not for the substance because the rule varies from jurisdiction to jurisdiction, but I'm just providing you here an example of what a rule for battery might look like. So I'll just go ahead and read it. A defendant is liable for battery if he acts intending to cause a harmful or offensive contact with another and a harmful or offensive contact results. So you can see that no matter what the factual situation is, if there's a potential harmful or offensive contact or touching, right, this general rule regarding battery could be applied to those facts. Okay, so the application is, again, going back to that graphic. It's really at the heart of what we do as lawyers. So we receive information from our professor, but the real key is not just to understand that information on a superficial level. It's to understand it and be able to engage in the critical thinking to produce something new with it, right? And that something new is legal analysis. So I call the application the big A, right? Because this is where most of your points come from. As I said before, anybody can memorize a set of rules, but it's applying that set of rules to the facts that really shows that you're able to do the critical thinking required of a lawyer. So it's about marrying law and facts together. How do the words from the rule fit with the facts that you're given? So, a classic sort of example of battery might be Amy spit on Joan. Okay, I'm just pulling those names out of my head. And, spitting doesn't necessarily hurt someone, but it certainly could be considered offensive, right? So, if you are applying the rule we just talked about, for battery, you don't just say Amy spit on Joan, you would tie that to the rule words. So you might say something like, when Amy spit on Joan, which is the fact words, she engaged in an offensive contact. The contact was not harmful, but it was offensive for Joan to be spit on. So I'm just pulling that out of my head, but you see how talking about the facts, the spitting that occurred, along with using the rule words, harmful or offensive, tied together, create legal analysis. Students often make the mistake of just saying, Amy spit on Joan, period. Therefore, a battery occurred. No, that's just simply restating the facts. It's not tying it to the rule. And you can't expect the professor to assume, well, the person found the spitting in my fact pattern, so the person must know why that's relevant. You can't assume it's obvious. It's like a math problem. You have to show your work. And so you show your work and show your thinking by tying those fact words and the rule words together. So when you go to engage in your application or your analysis, I want you to think about these two puzzle pieces here and realize that those sentences, when I write them, have to include words from the rule and words from the facts. Okay, so you have to be thinking about tying these things together. And there's often a way that I advise students to check whether they're simply reciting rules or reciting facts. And it's a highlighter method. A lot of people teach this in their courses. And what they say is pick a color for the facts and pick a different color for the rules. So if you pick yellow for the facts, Amy spit on Joan, right? That would be yellow. And then when you use the rule words, which constituted an offensive, right? Offensive contact, right? So when you use the rule words, you do those in another color, green. And so what you should see in your sentences, in your application section, is both yellow and green. And if you only have yellow, you're only talking about the facts. If you only have green, you're just reciting the rule, but not explaining how the rule and facts are tied together. So you really have to show your thinking to be able to get all the points. And this brings us to the conclusion. So the conclusion is the answer to the legal issue. It's tied directly to the legal issue. So it's a declarative sentence, really nothing more about the likely outcome. The thing about law school exams is that there's rarely a right answer. So they are not written to be 90-10. So 90% a certain way, there's a 10% chance that you could find it the other way. They're written more like 60-40. There's one side that is slightly better than the other, but really 40% could go the other way and it would just be fine. And in those cases, if you're stuck on what the outcome is, you can acknowledge it's close, but you have to reach a conclusion. And so, some students may be frustrated to hear the reality that two students could write A papers and A essay answers and have a different outcome. And the reason is because it matters how you get there. It matters how you apply the law and facts together to reach your conclusion. The conclusion in and of itself is not where the points come from. Okay, so let's just use an example. This is a variation of what I used in my case briefing video, if you watch that, but I tweaked the facts a little here. Just a random, straightforward example to show you how the IRAC paradigm might work. Essay answer might say something like this. This is very straightforward. Whether the plaintiff pled special damages sufficient to support her slander pro quod claim. Okay, Doesn't matter if you don't know what a slander per quad claim is, because we're about to tell you what's needed in this particular case in the rule, which we know is a general statement of law that applies to any case involving similar facts. So special damages are monetary damages that are quantifiable, such as lost wages. Okay, so if you listen to the other video, you know that slander per quad is saying something bad about something else that requires the listener to make an inference, and that results in damages. And here the rule we're looking at is the requirement that special damages be alleged. Special damages are monetary damages that are quantifiable, such as lost wages. Okay, so we're looking at the damages piece here. That's our rule. And if we applied it to facts, we could say very simply here, plaintiff lost wages, which are quantifiable monetary damages. And what I want to show you in that application is lost wages are something that we got from the facts, right? Plaintiff pled lost wages, saying, I lost this much money as a result of the conduct. And then I tie that to words from the rule, which are quantifiable monetary damages. Therefore, in the conclusion, plaintiff pled special damages sufficient to support her slander pro quad claim. Okay, so just to quickly look at that, so the issue is what the judge would decide, whether plaintiff pled special damages, right? And the rule we know is a general statement of law that can be applied to another case. And again, the application has the fact words and the rule words in there. And the conclusion is an answer to the issue. We said the issue was whether plaintiffs pled special damages, and then the conclusion answers that question. Yes, plaintiff pled special damages sufficient to support her claim. So let's just dig into a more complex example now. So let's go back to battery. And again, this is not to teach you battery because the definition may vary in terms of the number of elements depending on where you are. But for our purposes today of learning how to engage in legal analysis using IRAC, we're going to use this definition. So battery is the intent to cause harmful or offensive touching of another. So that has three components. Three what we call elements that make up that intentional torts. And the result is that we're not going to do one big IRAC analyzing three issues, because think about the busy user. How would that be to sort of have to go through one huge paragraph dealing with three elements? It might look something like the issue is whether the defendant had the intent. And then the issue is whether the defendant had caused a harmful or offensive touching. The issue is, right, so you see it would just be repetitive, dealing with the intent, dealing with harmful, dealing with the touching in the issue statements, then dealing with the rule for intent, the rule for harmful and offensive, the rule for touching, and then the application of the intent, the application of harmful or offensive, the application of touching, and then the conclusion on each of those three elements. And that's kind of hard to read. And think about your professor sitting there with a rubric trying to figure out, okay, where's the intent piece? And having to hunt around for that. We're going to make that a whole lot easier on your professor, on the court, by using what we call mini-IRACs, okay? So what that means is that each element gets its own IRAC, okay? So if you have a question on battery, which we know is the intent to cause harmful or offensive touching of another, we are going to do a separate IRAC for each element. So one for intent, one for harmful and offensive, and one for touching. And so therefore, it will be very easy for your professor to find, okay, I'm looking to see whether this person knew the rule for harmful and offensive. Okay, so we have our heading, which is our issue, and then we have the issue statement. Oh, well, the professor knows just where to look for that. Or if the professor says, okay, well, this case really turned on the touching, and that's worth a lot of points. Let me find that there. Again, the professor is going to know to find it in this mini IRAC. Okay, the pieces are the same, like the issue, the rule, the application, the conclusion, and it's the same concept. You're just doing several IRACs instead of one big IRAC. And in your big picture IRAC, this constitutes the analysis. So I'm going to show you what that looks like. So again, this is a battery question. So we might have a heading up above this that says battery, right? And we have then a statement that is our issue statement. It's the legal issue being addressed in this answer. And here it's whether the defendant is liable for battery when the defendant accidentally hit plaintiff with a golf club, even though defendant only intended to scare plaintiff by swinging the golf club near him. So that's our global issue statement. That is our big I in our big IRAC, right? So IRAC down the left-hand side in this gray area, that's what we call our global or our big IRAC, okay? So the big rule that we're going to break down is battery is the intent to cause harmful or offensive touching of another. And so that's our global or our big rule statement. Then we have the A, the analysis, which as we discussed, each one is a mini IRAC, right? So the issue is whether the defendant acted with intent. We're going to provide the rule for an intent, and then we're going to say here, defendant, law words and fact words. Therefore, we're going to answer the issue in the conclusion. And we're going to do the same thing for harmful and offensive, and we're going to do the same thing for touching. And each of those has their own separate rule, and they're going to have their own separate application, where we marry the rule words and the fact words together to reach a mini conclusion. And then we're going to have our global conclusion, and that's going to examine whether these things were met or not met, right? And that's going to lead us to our conclusion. So if battery is the intent to cause harmful and offensive touching of another, and there is no touching, right, then we know, because that element is not met, defendant is not liable for battery. Or if, for example, there was a touching, but it wasn't harmful and offensive, someone just bumped into someone else and didn't cause any sort of damage or harm, and it wasn't offensive, we would say the defendant is not liable for battery. And we're answering, again, the question raised in the issue. So let's get back to the particular issue in this case. Whether defendant is liable for battery when defendant accidentally hit plaintiff with a golf club, even though defendant only intended to scare plaintiff by swinging the golf club near him. So what do we think is going to be the real important piece of this? So you have to include analysis unless the instructions tell you not to. So the mini IRAC for intent, harmful, and offensive, and touching, but one of these, based on these facts, is going to be more important than the other. And this case is really going to turn on intent. And the issue tells you, even though defendant intended to scare the plaintiff. And so what is that you think going to be dependent on? It's going to be dependent on the rule for intent. What does that require, right? So that's what we're going to pay particular attention to. And so your conclusion might be, therefore, defendant is or is not liable for battery, when defendant accidentally hit plaintiff with a golf club, even though he intended only to scare him, or something like that, using the facts there in that global conclusion. So that's what a big IRAC will look like, and you will get this. This might seem like, oh my gosh, I'm not really sure what to do with this at this point. It's really a matter of practicing writing the I, the R, the A, and the C, looking at sample answers and saying, okay, is this an issue sentence? Is this a rule sentence? Is this an application sentence? Each of your sentences should serve a purpose. And so when you're writing a practice exam, if you are struggling with your use of the IRAC paradigm, go back and label your sentences. What is each one for? And if you see that there were a whole bunch of facts, for example, relating to harmful and offensive, and you only dealt with one, you want to go back and see how else could I have added to this to make my analysis my application more in-depth and meaningful. So you will get this. It is a formula, and that by definition sort of makes it easier. You don't have to guess as to what you have to include. You just have to be comfortable with working with the formula, know that there's a reason for it, and really take my word for it that at some point it becomes second nature to you. I never think about the formula when I write. It's just now naturally the way that I write. So just know that you can do it. You will get there with practice. And as always, I'll be rooting for you. Thanks.